After a slew of copycat petitions across India arguing that mandirs once stood where masjids stood today, the Supreme Court has made a critical intervention. Chief Justice Khanna has taken a very different path, some might argue, from his predecessor, Justice Chandrachud. I'm Barkha Dutt, you're with the Mojo Story. Our focus today is on the much debated Places of Worship Act before the Supreme Court now, and the Supreme Court making a critical intervention on a bench led by Chief Justice Khanna has stopped or at least paused and halted trial courts from admitting petitions or allowing surveys to examine whether temples stood where mosques stand today. We have seen tensions rise over such petitions, whether it comes to the Sambal area in Uttar Pradesh, where there was actual violence on the streets, or the sacred Ajmer Dargah. Before that, of course, Gyanvapi and Mathura have already been before the courts. Remember, during the Ayodhya verdict from the Supreme Court, and one of the authors was former Chief Justice Chandrachud, the Ayodhya verdict clearly said, while granting the Ram Mandir, the right to be built at Ayodhya, that the Places of Worship Act must be upheld and protected. And in fact, the Ayodhya verdict described opposition to the Places of Worship Act within the basic structure of the Constitution, which means that Parliament cannot simply or easily change it. And yet, when it came to the Gyanvapi petition, then Chief Justice Chandrachud held that merely allowing a survey did not violate the Places of Worship Act. Chief Justice Khanna has taken a very different view from his predecessor. All trial courts have been given a clear signal till the Supreme Court itself decides on the validity of the Places of Worship Act and takes a final decision on that. Copycat petitions of the kind we've seen from Ajmer to Sambal will no longer be allowed. It's a critical intervention. The debate, of course, will carry on in the public domain. Joining me now is one of India's finest legal thinkers and scholars. I want to welcome Professor Faizan Mustafa to the program. Faizan Saab, good to see you after a very long time. I know that you've had certain unconventional views on how to resolve these differences when it comes to places of worship. But before we get to that, we have seen literally a slew of copycat petitions. There was a temple at Ajmer. That petition was admitted. In Sambal, of course, an entire survey was commissioned. And now the Supreme Court has intervened to say that survey cannot be made public. The Supreme Court has also said no more surveys, no more petitions to be admitted till such time as the Supreme Court takes a final decision. How important is this response from the Supreme Court, according to you?
Barkha, thank you very much for having me. I'm not surprised at today's order because this is a very good bench to hear this matter. And Chief Justice Khanna is a man of few words, but a very sound judge. So I thought that nothing much is going to happen today because so many intervention applications have been filed. So there
Yes.
are application from intellectuals, most of them are non-Muslims, from number of Muslim organizations. So to hear the constitutionality of a matter like this, the court has to appoint a nodal advocate who will collect all the pleadings, and then the date would be fixed and a hearing would take place. Not more than 3 days would be given to this act, maybe 2 days. Because when a constitutional bench hears a matter, on that day only one matter is heard. So when Places of Worship Act would be heard from 10:30 till around 4 o'clock, you will have arguments only on this matter. Now, what is very welcome and pleasing that the Supreme Court of India, understanding its duties under the Constitution to protect the rights of citizens, has for the first time taken a very strong action in terms of prohibiting all the courts below from entertaining any more application of this sort, and also prohibited the courts which have already taken the cognizance of these petitions or have made interim orders of survey, etc., that they will not pass any more orders on those petitions. So for the time being, I think the sanity one hopes would return, and we would first have the constitutionality of law examined. Barka, I had written that even on NRC, before spending about 1100 crores, when the constitutionality of the Section 6A of the Citizenship Act is in question in Supreme Court, let the Supreme Court first decide the constitutionality. So I think in this case also let the court first decide the constitutionality. And if court finds that the law is unconstitutional, then there would be a flood of such cases. If the court says that the law is absolutely constitutional, it would be a full stop to this kind of filing of cases.
Let's talk about the law. For those who don't know, a large part of our audience is young and was not even perhaps born in 1991 when the Places of Worship Act was passed. Now, the Places of Worship Act was passed when it was a Narasimha Rao government. It was passed always with the exemption Professor Mustafa of Ayodhya built into it. And it basically says that places of worship, the religious nomenclature of a place of worship, shall be frozen as of 15th August 1947, with the exception of Ayodhya and with the exception of those that have archaeological importance, right? That tomorrow a new discovery could be made, etc. Now, the important thing is that when the Supreme Court grants the mandir to be built in Ayodhya, it has a very, very strong passage on the Places of Worship Act, which it says falls within the basic structure of the Constitution. And as we know from the Keshwanand Bharati case, whatever is deemed to be part of the basic structure cannot be changed by a change of mood in Parliament. Now we're back to the Places of Worship's constitutionality being before the Supreme Court. How do we understand these contradictions, these mixed signals from the Supreme Court itself?
See, Barkha, there are two kinds of arguments which are made about Babri judgment. One, that the court wanted harmony and peace rather than justice, and therefore they decided to decide in favor of DT and gave an alternative land of almost double the size of land which
Yeah.
was the Babri Masjid, erstwhile Babri Masjid, where it stood once. So it was buying peace to restore harmony. Now, one judge in the Allahabad High Court, from where the appeal came, had expressed some doubts about the 1991 Act. Remember, the judgment of Allahabad High Court is coming in 2010. So by that time, the 1991 law was already there. Now, when justices of Supreme Court, we don't know who really authored that part because it is a strange judgment with judges not even mentioning the names who wrote the
Yes.
judgment, who
Although the
concurred.
although the although the buzz was that Justice Chandrachud, not then Chief Justice, was the
So let us
principal author of the Ayodhya verdict.
yeah, let us not speculate and say that all of them were party to it. They are saying very strongly that 1991 Act is an act which furthers the cause of secularism, and non-retrogression is the principle of our law, that we would not try to correct the historical wrongs. They specifically make a mention that wrongs committed by the Mughal emperors or by the ancient kings cannot be corrected today through the courts of law. And therefore, one got an impression that the controversy about all other places of worship is over. But immediately after Ayodhya, even though we were during COVID, applications were filed and petitions were filed challenging the constitutionality of 91 law, and also for the survey in Gyanvapi and in Mathura. Now, what the petitioners who are challenging the constitutionality are saying, one, that the exception of devotees of Lord Ram in Ayodhya is basically violating the right of equality of devotees of Lord Krishna and Lord Shiv in Banaras. This is one argument. The other
Mhm.
argument is that how can you fix a date of 15th August 1947? Some say that it should go to first battle of Panipat of 21st April 1526. But I think those who are saying this are not aware that even prior to first battle of Panipat, for 300 years, Muslim dynasties were ruling over Delhi during the Delhi Sultanate. The others say that it should be 1206 when Qutbuddin Aibak founded Delhi Sultanate. And then there are others who say it should go to 712 when Muhammad bin Qasim, conquered Sindh. This is
Mhm.
second line of argument. The third line of argument, which I think is the heart of these petitions, and those who are opposing these petitions, the Muslim parties and the Dargah parties, they have to meet this argument. The argument is that you are absolutely excluding the judicial review, which is also a basic structure, just like secularism, because you are saying that no court will entertain any petition for the conversion of any place of worship. And if
Yeah.
any case is pending in any court, it will abate. So the argument is that this law is excluding judicial review of all parties, and therefore it is violating
Mm.
of basic structure. So it
I
may be,
understand.
I
Let
think
me
yeah.
paraphrase that. Let me paraphrase that in my layperson's language. You are saying that the reason that the places of worship's constitutionality is back before the Supreme Court, despite the fact that the Supreme Court bench in the Ayodhya verdict held it to be part of the basic structure of the Constitution, is because the refusal of judicial review is also a part of the basic structure of the constitution. So you have
True.
two tenets that are part of basic structures, possibly at odds with each other, which is what the Supreme Court has to settle.
And that's why I'm saying that there is a difference. One, they are saying that we have a freedom of religion, so our fundamental right is violated. We want to pray, let us say, in Gyanvapi, or we want to pray in
Yeah,
Mathura or in
yeah.
Sambhal. Now, the problem with this argument is that nobody has a right to pray at a particular place. Freedom of
Hmm.
religion is there, available to everyone. But do you have a right to pray at a particular place? The answer is no. And this again is from Ayodhya litigation. You remember when
Hmm.
Babri Masjid was demolished, thereafter that piece of land was acquired by the government. Now, acquisition of land was challenged by a petitioner called Aslam Bhure and Ismail Faruqi. And there, the Supreme Court has said that Muslims can pray anywhere. So, unless a place has a peculiar importance, it doesn't mean much. So, there is no fundamental right for anyone to say that I will pray only in X temple or a Y mosque.
Yeah.
Two, there is no litigant here who is saying, Barkha, this land belongs to me, and therefore my right to property is violated. In any case, right to property after 1978 is no more a fundamental right. Here we are making a speculation that probably here there was a temple because X book says so or Y book says so.
So,
What
so,
is the
so this is not a title deed dispute. I understand
That's
what
right.
you're
So
saying.
no
I
litigant in his own is
yeah.
there.
Now, somebody in our audience, one of our very regular viewers, Prasad, has an interesting questions. Barkha, for the sake of legal clarity, is there a need to differentiate between worship in bracket of idols versus prayer bracket in a mosque? Is there a legal distinction? Because when it comes to Gyanvapi, for example, you yourself, if I remember correctly, on my show said that on Gyanvapi, you thought it was best if the Hindus and the Muslims sat together and resolved this. You said on Gyanvapi, you thought the Muslim groups had a weaker legal case than they did on Ayodhya. When Supreme Court, Justice Chandrachud, held that the survey in Gyanvapi did not violate the Places of Worship Act, he opened the floodgates for all of these copycat petitions that today's Supreme Court has now stopped.
True.
But is this going to solve the tensions between the two communities? Or does the solution lie outside of the courts?
No, whatever happens, whether court upholds constitutionality or strikes down this law, tensions will not die down. My solution is I stand by my views. I have written in Indian Express also on this that unlike Ayodhya, where there was no evidence that a Ram temple was demolished to construct Babri Mosque. Archaeological Survey of India, which is a government of India department, doing this survey under Vajpayee government's Ministry of Culture, had also not said that a Ram temple was demolished. Nor the judgment is based on this, that since a Ram temple was demolished, therefore we are, in fact, they are saying that whatever you find beneath the surface cannot determine the title, which is the correct position. I was making a larger argument that if there are disputes like this, and in case of Mathura and Kashi, historically speaking, there is evidence available that Aurangzeb, for whatever reason, I am not going into the reason, partly demolished these temples. And therefore, it is better that rather than we take the litigation route, the way we have taken in case of Ayodhya, I have very strongly said, if you recall, Barkha, that local community leaders should sit together and through mediation and arbitration resolve this dispute locally. And why I said so, Barkha, in litigation, one party will win, one party will lose. In mediation and arbitration, both will win. And therefore, it is a better solution.
But
So for
the court did try mediation in Ayodhya and it didn't work. What makes you think
it
mediation in
was a
Gyanvapi
late,
can work?
it was a late attempt. In fact, I was reading today morning itself, Barkha, on 1991, Subramaniam Swamy, who is also a petitioner now in Supreme Court, there has very clearly spoken in Rajya Sabha that the Muslim parties had agreed at that point of time that if a retired Supreme Court judge heads the commission, whatever finding they gave, that if a Ram temple was demolished, let us have mosque. It is the Vishwa Hindu Parishad which did not accept. And he supported this law on the floor of the House.
If a Ram temple was demolished, let us have mandir, you mean? You said let us have
No.
mosque.
Yeah.
Yeah.
Even at that point of time, they had
Yes.
agreed that if you bring the evidence that a Ram temple was demolished, have a mosque. But I'm on a different point. When Justice Chandrachud is permitting survey, why everyone is saying he opened the Pandora box and opened the floodgate of litigation? If you cannot convert a place of worship, cannot change the character of that place, you are unnecessarily creating rift in the society, giving rise to ill feelings between the communities in such a surcharged atmosphere. So what is a great fun to know whether this thing originally was X or Y? And when the law does not permit that, ideally he should have done the same thing which Justice Khanna has done today. But
Correct.
he said, doing a survey is not prohibited. Conversion of a place of worship is prohibited. But I will bring to you, Barkha, another law which has not been talked about at all in this debate. Everybody is saying, all these petitioners are also saying that, well, look, any structure or any place of worship or building or whatever, if it is more than 100 years old, it is a protected monument. And if it is a protected monument, under the Places of Worship Act Section 4, there is an exception. And if you are covered by that exception, then Places of Worship Act does not apply. Now, this is an absolutely flawed argument, Barkha, because we are ignoring a provision of a law which governs Archaeological Survey of India. And what is that law? That law is Ancient Monuments and Archaeological Sites and Remains Act of 1958. And their section 20O very clearly says, no court shall have jurisdiction in respect of any matter which the authority, which means ASI, is empowered by or under this act to determine, and no injunction shall be granted by any court or any other authority in respect of any action taken or to be taken in pursuance of any power conferred by this act. Therefore, the law governing archaeological survey of India itself bars any court from even taking cognizance of any suit.
But in that case, sorry if this is a silly question, but in that case, why does the law have two exemptions? One, Ayodhya, and two, this archaeologically significant monument, right? That is an exemption built into the Places of Worship Act. That is the one that is being cited by those who bring their petitions to trial courts. That archaeologically, एक जमाने पे यहाँ पे मंदिर था, उसको तोड़ के ये मस्जिद बनाया गया. That exemption, why does it exist? What is its purpose in the Places of Worship Act?
There is a purpose. One, that any building which is more than 100 years old, it may have a religious character, whatever, it is part of our heritage. And therefore, the government has a right, even if it is a private property, to force the owner to have some kind of agreement about its protection, about its maintenance. Say, if I'm living in Patna right now, Barkha, if tomorrow it is found that in my house Ashoka was living, now Government of India can straight away say and come that this is a protected site now, and you will not be allowed to alter its boundaries and its maintenance, and everything would rest with us. But under that act itself, in section 16, also it is written very clearly that if a protected monument is a place of worship, then nothing can be done which is inconsistent with its religious character. Therefore, section 4 and the Archaeological Sites and Remains Ancient Monument Act, they are consistent, they are not inconsistent.
Yeah. So let me ask you this. Although personally you believe that the Gyanvapi dispute in particular, and disputes like it should be settled locally and not through the court of law, you also believe that Justice Chandrachud as Chief Justice, by allowing the survey and saying, oh, the survey by itself doesn't violate places of worship, opened a Pandora's box that Chief Justice Khanna has today attempted to close.
Correct. That's correct. But more than Justice Chandrachud, of course, he opened the floodgate. Let us look at the Sambhal case. Why are we doing a survey? You know, there is a principle in law which is said res judicata. If a matter has been decided by a court in respect of a subject, it cannot be reopened again. Now, about the Sambhal Mosque, already in 1877, you had a judgment from the Muradabad court. Then an appeal was filed in the Allahabad High Court. And Allahabad High Court has said that on law and facts, the judgment is correct. And this judge who decided the case in the Muradabad court, under whose jurisdiction Sambhal was at that point of time, he himself went to the mosque and he himself made an inspection. As we say in Hindi, the Adalat apne aap mauqe wardat par maujud thi ya gayi. So Adalat ne wahan jaakar dekh liya, forget about any surveyor submitting any report. So the Sambhal court, this Chandosi court, which entertained Sambhal petition, it went against the principle of res judicata also. In Mathura, there is another exception to Places of Worship Act, which says if it has been settled through a settlement. So there has been some kind of settlement in Mathura. Strictly speaking, by law, you have to go by that settlement.
So what now? Ab kya hoga?
No, I think for the time being, you will have a temporary peace. Then the Supreme Court will hold a hearing on constitutionality. All of us will report and read what kind of arguments are made by both sides. If Supreme Court says that the law is constitutional, hopefully this debate would come to an end. I would still say, even if that happens, is still the Muslim community, the local community of Mathura and Kashi should sit together with the Hindu community locally without involving clergy, without involving national political leadership, without involving political parties, without involving organizations which say we are a cultural organization but basically are supported by the political party, and resolve the dispute amicably in such a way that both come out as
But
winners.
you have named Mathura and Kashi.
And because of the
Will it
peculiar significance.
I I understand. But then the hope must be, if communities are able to resolve this locally between themselves, keep the courts out, keep the politicians out, keep the clergy out, keep the religious leadership out. Great. Will it end there? There has to be a cut-off point wherein even the RSS chief, and this bears repetition, has said that you cannot go looking for a shivling under every mosque.
Barkha monster is out and in nobody's control. Now, this thing cannot be controlled by anyone. Now, if Supreme Court bars filing of any suit, at least the judicial forum would end there. But
Yeah.
I always feel that no law means anything. Parliament can repeal the 1991 law as well.
But it'll need two-thirds majority for any government to do that.
No, no, no. It is an ordinary law.
No?
It is
Oh,
an
it's a
ordinary
regular
law.
law.
It's an
Okay,
ordinary
hang
law.
on. So sorry, I
Or
got
it
that
can
wrong.
be
The
amended.
law.
Or it can be amended. But I am 100% sure there is no better and appropriate date, cutoff date, than August 15, 1947, because colonial rule came to an end. We are making a new beginning. So whatever character was there on that day. Now, many people are trying to confuse it.
I have a question. Sorry, I'm being a little buddhu
Go
here,
ahead,
but
go ahead.
allow me the question. You said Parliament can amend the law. My understanding was that because the Ayodhya verdict positions or says very clearly that the Places of Worship Act falls within the basic structure of the Constitution, the Parliament cannot amend this law as a simple law. Am I wrong?
No, it's not a question of wrong. You are not a student of law. You see, secularism is basic structure. Places of Worship Act is in pursuance of secularism. This is what the court has said. But
Right.
Parliament can modify the law if it wants. If it feels like, it can also repeal law, and no court would be able to do anything about it. But a likely scenario and better
I mean,
scenario would
the court can't say at that time theoretically that this change of law is in violation of the basic structure. This has weakened secularism, and therefore we do not agree. You see, after all, the Parliament unanimously passed a law on the appointment of judges, and the Supreme Court intervened and stopped that.
Yeah, that's right. No, Supreme Court won't be able to say that. Let us assuming
Yeah.
hypothetically that Parliament
Yes.
repeals this law because the basic structure doctrine is to be invoked only in respect of constitutional amendment.
I
This is
see.
an ordinary law.
I see. I
Yeah.
see.
So
So a
if they make a
constitutional
constitutional
bench,
amendment
a,
which impinges on basic structure, then then Supreme Court can strike down that amendment.
got it. Got it. So a constitutional bench will have to decide on the constitutionality, but Parliament technically, technically can repeal or change this law, and the Supreme Court can't really do anything about it.
No, they may strike down that law if they find that this law is arbitrary,
Yes.
or if it violates any fundamental right, or it is contrary to constitution. They may
Right.
still strike it down. That power will be with the court to examine the constitutionality of any legislative action. That is there. But for our country, when we say that nothing explains India better than diversity, we should bring these religious disputes to an end. If secularism really means modernity, it should have led to some kind of decline of religions, but we are living in the rush hour of God. We are all the time talking about religion, and that is not a good sign for us to become a developed country or Viksit Bharat by 2047.
Rush hour of God is quite the phrase of the day. Just before we close, what would be your hope from the Supreme Court? The Supreme Court has, as you said, halted this kind of copycat domino effect that we were seeing in trial courts across India. That is clearly gone. It will take its time in establishing constitutionality of this law, as you explained. What would be your hope at this point
I,
in terms of
I,
expectations from the Supreme
I,
Court?
I would expect that this will be one of the major judgments which, in this short tenure of 6 months, Justice Khanna would deliver. It is not right to predict what would be the outcome of a judgment. But if you are saying, as a student of constitutional law, my hope would be that the law will be upheld as constitutional because it is a big public policy issue. It's a decision,
Yeah.
how do we end this debate? And therefore, we
Yeah.
say, you asked about the Ayodhya exception because it was already sub judice. The matter was already pending before the court, and therefore they said that accept this, for rest of these matters let us not change the character, whatever be the character. And to determine a character, Barkha, I would very strongly say no survey is required. You can see if it is a place of worship from 1 kilometer, whether prayers are going on in terms of namaz, or if it is a church, whether Saturday, Sunday, prayers
Mm.
are going on, if it is a temple where worship is going on. I personally don't really feel any difference. Someone asked that question between namaz and worship. Both are covered by freedom of religion. Both are covered. So there is absolutely no difference, except that for Muslims, the God is not there in that place as such, but we say mosque is a house of God. And idol is there, then you are praying to idol. But even amongst the Hindus, you have people who are nirakars, and people
Mm.
who are believe in Sakar God. So Arya
Mhm.
Samajis are Hindus and they don't believe in idol worship. So how do you do the worship? That is not a point. Is it a place, a religious place? The character of a religious place can be seen from a distance without any inquiry and without any survey and without any archaeological evidence. Because a character should be seen visible. You need not dig the ground to find out the character. In fact, one of the weakest point of the Babri Masjid debate is, had mosque not been demolished, no one would have ordered the kind of
Mm.
ASI survey which was done there, because it was
Yeah.
demolished. That's why you were able to do it.
But prayer is a complex thing, like Gyanvapi. I think it was you who said, oh, that both communities can pray. Prayer is a complex thing.
What I had said was this: ideally, they should resolve amicably
Mm.
and resolve in such a way that both have a feeling that we have won. I
Mm.
don't know what will be the concrete
What that
solution.
might look like. Yes.
But I had also said, and I had written, that if both cannot pray, let us say, it would lead to further, escalation of tensions, and then one may be allowed a silent prayer, that, or both may be allowed a silent prayer, that here is a dedicated place for you, here is a dedicated place for you, but both of you can pray, but come and pray silently. That would be a model we would present to the world, that look how a civilization which is 7,000 8,000 years old can resolve contentious religious disputes.
Well, I mean, we look forward to models of resolution in the way that you imagine them. And we also look forward to a halt in these copycat petitions. You are right, the Justice
But they're
Khanna,
very
Chief Justice of
poorly
India.
written petitions. But any good judge should have dismissed them straight away at the face of it.
Well, now
Very
there's a
badly written
very
petitions,
clear signal.
hurriedly done. Hurriedly
No,
done.
but but clear signal from the top bench and the top judge of the country. So I think, as you said, a momentary balance to public discourse should be restored. We leave it there. As you said, Justice Khanna, in the next 6 months, will be deciding, probably delivering his judgment on this critical matter, one that will impact not just politics, but the social fabric of India. Thank you, Professor Faizan Mustafa. Always a pleasure. One learns so much from you each time. Thank you so much.
Thank you.
Thank you. Take care.
Okay.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.